This is the current federal tax developments for the week of March the 6th, 2026. Current federal tax developments are brought to you by your state society of CPAs. Today, we're going to dive into significant recent guidance and court decisions that can directly impact how we advise our clients and manage various tax controversies that come up. So let's get started by looking at what happened this week. We're going to first discuss the highly anticipated IRS delay of the Secure 2.0 required minimum distribution regulation effective date. They had expected to have something out by now for the various things they'd reserved when they issued final regs. Now we're going to see that we're going to get a little bit of a time frame to be able to understand whatever new final regs come out before they have to be implemented. So we'll talk a bit about that. We're going to review a tax court decision addressing whether a taxpayer can challenge underlying liabilities in a collection due process hearing after they ignored an IRS offer of appeals. We'll discover the answer is not going to be good for the taxpayer in this case. Third, we're going to unpack a complex partnership tax law case involving Section 743B adjustments. Those are the adjustments that are made when you have an acquisition of a partnership interest and you have the outside-inside basis differential. We're also going to discuss the economic substance doctrine with regard to this transaction and defenses against penalties. And finally, we're going to look at a Second Circuit ruling that confirms the IRS authority to administratively assess Section 6038B penalties, like for the Form 5471 failure to file, without having to take it all the way into the U.S. District Court. In essence, they can use their standard assessment abilities there. The tax court has said no, but this will be the Second Circuit, not just the Second Circuit in the name of which circuit did it, but the number 2 circuit after we had, I believe it was the Federal Circuit, that had come up and said, nope, they don't need to go to court. Go to the District, DC Circuit, as I recall. Then it's got to be a tax court circuit. So we'll get back to that. Well, let's go ahead and we're going to kick things off with our first topic, which is IRS Announcement 26-7, which came out on February 23rd. This announcement addresses the shifting regulatory landscape surrounding required minimum distributions under changes made by the Secure 2.0 Act. So let's talk a little bit about these regulations and some backgrounds. The IRS published extensive proposed regulations in July of 2024 to integrate Secure 2.0 Act changes, originally targeting an applicability date of January 1st, 2025. And as many of you may know, during the comment period and the September 2024 public hearing, there was massive pushback from various industry stakeholders. Plan administrators and tax professionals made it clear that achieving operational compliance by the start of 25, we're having a September of 24 hearing, would be virtually impossible because of the sheer volume of structural adjustments required. The IRS explicitly acknowledged this heavy-duty burden and anxiety caused by the uncertainty of having these rules still in the proposed phase coming up on year end. As a result, they delayed the effective date for most highly technical sections, specifically those dealing with termination of designated beneficiaries and distributions from defined contribution and defined benefit plans. So what exactly did we get in terms of relief here? Well, this announcement grants plan sponsors and taxpayers what is going to essentially be a floating runway. Rather than locking in a rigid date under which we expect the regulations need to be complied with, we're going to rather say that they'll first apply for distribution calendar years beginning no later than 6 months after the final rules are formally published in the Federal Register. Now, the 6-month buffer is kind of essential, so you can't be forced to overhaul your systems mid-year without adequate lead time. Until that applicability date is triggered, we're not left in a full regulatory vacuum. During that time, the IRS mandates an interim transitional standard that you must apply reasonable good faith interpretation of the underlying statutory provisions of the Secure 2.0 Act. It's important to make it clear. You're not allowed to ignore the Secure 2.0 provisions. You can't say, I don't like that, so we're just not going to do anything with it. You're going to have to implement things in Secure 2.0, but there is no standard IRS guidance. You're going to rather have reasonable good faith interpretation. That gives us significant but not unlimited leeway in how we want to handle these particular issues as we go forward. And again, with the 6-month rule, it means that January 1st, 27 is the first date we could actually have to face implementing these things. And more to the point, if they don't get around to issuing these regs in final form by July 1st of 26, then we're going to be waiting until at least 28 before we would have to implement these rules, and we could use reasonable good faith interpretation. Bottom line, basically, those in the industry were complaining that, you can't just come in at the last second and we have to implement in a month or two. So this guarantees at least a 6-month time frame before you'll have to implement these new regulations. Okay. Now, what exactly was delayed by announcement 26-7? A few things here. Their impacts on beneficiaries and spousal election. Now, this delay directly affects the proposed update to Section 1.401A9-4, which refines the rules for eligible designated beneficiary. A crucial point here is limitation on a surviving spouse's subsequent beneficiaries. If a surviving spouse dies after benefits have commenced, their beneficiary is not considered an eligible designated beneficiary, meaning the 10-year payout rule applies. Furthermore, the delay gives plan sponsors much needed breathing room to implement the operational defaults, for spousal elections under Secure 2.0, Section 327. Under the proposed rule, if an employee dies before the required beginning date, the sole beneficiary spouse is automatically treated as having made the election to be treated as the employee. However, if the death occurs on or after the required beginning date, it's not automatic, and the plan needs time to amend their documents to establish these defaults without facing penalties. So, basically somewhat important issues that we have to do. Now, remember, we're going to talk about this. And again, remember, the issue there about the surviving spouse's benefits, benefits commencing, that's if the surviving spouse is treated him or herself as an EDB. Now, remember, under many situations, like with IRAs, a surviving spouse is able to treat that account and roll it into their own account. So that will not cause a taint. That will mean that their beneficiaries can't be EDBs. What will is, however, if they're taken under the EDB rule, where they're allowed to use their life expectancy, right, but not treated as their own, which seems likely to come up in a trust arrangement, then, a successor beneficiaries never get the EDB treatment. And that's basically a standard rule that's in the regs and that they're looking to implement. There's also some affected items on Roth accounts and corrective distributions. Secure 2.0 explicitly excluded designated Roth accounts from lifetime minimum distribution requirements. Now, the proposed reg under Regulation Section 1.401A9-5 clarifies any distributions made from a designated Roth account during the year will not count towards satisfying the plan's overall required minimum distribution requirement. You got to advise your clients to calculate and satisfy their RMDs entirely from their pre-tax account balances. That would be part of the proposed regs. Therefore, a plan cannot treat it. And why that's somewhat important is, remember, previously when basically the Roths were part of the RMD, then distributions from any part of the plan would satisfy the RMD. Not so anymore. And this is, that's what the regulations implement. You also must advise your clients to separately going back here. If you're regarding missing a missed requirement distribution, Secure 2.0 reduced the excise tax from 25% to 10% for corrected distributions. However, you got to pay attention to the ordering rule in those regs. A corrective distribution for a past missed RMD is completely excluded when determined if the current year's RMD requirement is satisfied. So it made clear you can't double count, right? I think that probably makes sense to everybody. If I fail to take a $10,000 distribution in 2025, we just noticed that, and I take a corrective $10,000 distribution in 26, I can't then, let's say 10,000 was my requirement 26 as well. I can't count that single 10,000 distribution as both my corrective for 25 and my original for 26. I'm going to have to take a second $10,000 distribution if I elect to treat that first one as my corrective to get the 10% penalty. Okay. So yeah, that's double dipping doesn't work. That probably makes sense to you. But also talk about, in essence, this guy, qualified longevity annuity contracts, QLACs, right? So this is under proposed section 1.401A9-6. And this is practical relief for these annuities, right? Qualified longevity annuity contracts. Congress has fallen in love with the concept as a way to pay out a plan. If they're purchased with joint survivor annuity benefits, when divorce occurs before annuity payments actually commence, we have a bit of a complication. Now, the IRS recognizes that certain plans, particularly governmental plans, are not subject to standard qualified domestic relation orders or quadro requirements. For these exempt plans, the proposed regulations allow a standard divorce or separation instrument, such as a decree of divorce or written separation agreement, to safely substitute for a normal quadro. And this ensures that joint survivor benefits permissibility isn't negatively impacted by the lack of a former quadro when we get into that particular background, right? Okay. So finally, we got our nice little infographic again, right? This is a summary of the new requirement administration landscape and the timelines we just went over. So we talked about these regulatory applicants we covered, like the lifetime exemption for Roth accounts, the automatic spousal elections, right? Those are kind of the things we talked about there. And also the age 63, a 73 first 20 for 1959 births. Remember, that was also part of these proposed regulations, right? We have a problem there because the law as written basically gives two required beginning dates for those born in 1959. What this establishes is the reg said age 73. I would say a literal reading of the law would say that because, you got two required beginning dates, you're penalized for missing either of them. You got to take the earlier, right? Congress has the full right, if they want to go back and say, no. We always meant that people born in 1959 would take it when they turned 75. But unless they do that, the regs are likely going to stand because I happen to believe that the reg is the literal reading of the law. Literal reading of a very badly written law, but literal reading of the law. That's one of our backgrounds in that area. Now, over on the right side of this, in essence, we have the compliance timeline. They will apply no earlier than, essentially, at this point now, they were talking about delaying to 26. Obviously, it could apply no earlier than 27, and that's only if we get out by July 1st of 26. So we're there. So right now, we're into the good faith concept, right? We're going to do good faith standard and say we're going to kind of look at that and say, are we implementing these rules? Because again, you can't ignore the rules, but is your position a good faith position? If it is, it will be accepted up until the final regulations take effect. Okay, now we're going to take a look at a second major development of the week, and this one involves collection due process, normally referred to as CDP proceedings, and challenges to the underlying liabilities. Because again, remember, collection due process is a proceeding about collection alternatives for a taxpayer. But in certain circumstances, you can challenge the underlying liability in a collection due process proceeding. But there are rules for doing so because that's technically not part of the collection, right? In essence, if you owe the IRS X, we're not going to let you keep litigating that forever. We're rather going to force you, at some point it's accepted you owe X, and then we may still have collection options. So this is really what we're talking about here, right? And this is a recent and potentially consequential tax court decision, especially for, as in this case, you have representatives who come to the conclusion that the best thing to do is play hardball, right? We're going to play hardball, and we're not going to waste our time with things that aren't going to get us to where we want to go. In particular, an appeals conference when we fully believe that there is no way appeals is going to grant relief. So we're just going to skip that entirely. It would be pro forma only is our belief. Okay. Now, this is the case of Diversified Group Incorporated versus Commissioner. And also there's James Haber versus Commissioner as part of this, two taxpayers involved. And this was filed on February 23rd of 26. And this is guidance on whether a taxpayer can strategically ignore an IRS appeals offer and still preserve their right to challenge massive penalties later in a collection due process hearing. So let's take a look at the background. When did this case happen? How did it get us to the point where we're in court deciding whether or not at this stage in the proceeding, the taxpayer can still challenge underlying liabilities, or are they limited to questions regarding solely collection alternatives? Now, in this case, what we're going to do look at the background, I guess I want to say it. Between 1999 and 2002, James Haber and his corporation marketed unregistered tax avoidance strategies. They were, in the view of the IRS, son-of-boss types transactions, and basically they were, designed to generate non-economic losses for clients. Okay. Following an exhaustive 11-year examination, this went on for a while, the IRS issued notices of proposed adjustments in 2013, proposing rather massive IRC Section 6707 penalties on, failing to meet the requirements for this tax shelter of around $41 million for failing to register the shelter. And this is where strategic maneuvering began. In August 2013, the Taxpayers Council sent a letter attempting to preemptively waive all IRS appeals rights, arguing that the appeals consideration wouldn't be meaningful. Now, this is an unusual and aggressive posture, right? In essence, and I'm sure the theory was that we got to get in front of a judge, right? We're not getting anywhere administratively with the IRS. We need this into court, right? Before we're going to talk to anybody who's going to be willing to actually make a decision in our favor. Anything else would be a waste. So counsel tried to get by all IRS appeals. They're going to have to waive all their appeals rights. That was the background. Now, despite that preemptive waiver going in, the IRS followed its procedural protocols. In December of 2013 and February of 2014, the IRS sent correspondence explicitly offering the taxpayers post-assessment appeals conferences. The taxpayers completely ignored those offers, presumably relying upon the belief that their initial letter that had waived all of this meant they could safely ignore appeals, right? Now, so the IRS did formally assess the $41.2 million in penalties, right? So, and by the way, citation for this case, 166 DC number 2, right? Get that. So we have these proposed assessments, right, in this background, right? So they initially tried to litigate this via a refund suit, but because the penalty was indivisible, okay, which is they had tried to pay a small part of the penalty and then file in court and get the whole rest of it brought in, they were dismissed in the relevant court for not meeting the requirements because they violated the full payment rule. So they couldn't sue the U.S. government. They had to do that background. Once the IRS initiated collection actions through the liens and levies, the taxpayers requested a collection due process hearing. But here's the catch. Their central argument at the collection due process hearing was creative but risky. They claimed that because they had proactively refused a conference, they legally did not otherwise have an opportunity to dispute the tax liabilities. Now that's crucial because you're only allowed to dispute the liabilities, and in this case, the penalty liability is considered a tax liability, in a CDP hearing if you did not previously have an opportunity to dispute it. Now they're saying, when we said, no, we're not ever considering appeals, we're waiving all those rights, that, well, now we should still be able to challenge the $41 million underlying liability in the collection due processing because their claim is they never had an opportunity to challenge, to dispute that tax liability. It is, again, a bit creative and a bit aggressive. So how'd the tax court go with this, right? Now, when the case reached the tax court, the taxpayers threw what's essentially a kitchen sink of legal defenses at the judge to bypass the preclusion statute, because by statute, if you had a previous chance to dispute the liability and you failed to do so, this is not your ticket back in, right? You already had a chance, you waived it, the tax was assessed, end of game, right? You had your chance, you consciously ignored it, is the IRS view in this case. So first they said that, it would be meaningless. The opportunity to dispute was meaningless because an appeals conference would have just resulted in a pre-cooked outcome, right? Now, the judge in this case formally basically said, no, not buying it. You cannot refuse administrative remedy and then demand a trial based on the hypothetical inadequacy of the conference you skipped, right? Basically, you can't say, no, I won't go to conference. Say, well, if I had gone to conference, it would have worked like this. You didn't go. You need to go and have it go like this, okay? That's basically the background. And that would have been your ticket into court, but it would have been a direct dispute at that point, which again, they were hoping I would take it from the actions they took to be able to take this through either the U.S. District Court or the Court of Federal Claims. But now we're forced to be in the tax court, right? And let's face it, this appears to be the backup strategy, right? They're going to try to go here. So essentially, sorry, can't do that. Next up, they tried to invoke the Chenery Doctrine because the settlement officer didn't explicitly cite the IRS's 2013 offer level, but the court noted that Chenery applies to a deferential agency review, not a de novo review standard used for CDP preclusion. In a de novo review, the court looks at all evidence, right? Or I should say, right, in that state, not just what normally is a deferential agency review of reviewing the hearing or one of those things, a hearing, let's say, or a conference, where they only look at the record, right? Well, the fact that this might not have been part of the record is irrelevant. The court still considers that. So whether or not in this case, the 2013 offer letter, was specifically cited by the settlement officer, that doesn't really do it. We're reviewing the CDP hearing, but this is a de novo review because it is for preclusion of the issue at the collection due process level, right? Third way out. They attempted to weaponize the Supreme Court's recent Loper-Bright decision to invalidate the regulations that provide for these rules. However, the tax court pointed out that Loper-Bright explicitly preserves statutory stare decisis, and recent circuits had already determined the regulation was the best reading of the statute, or previous circuits. So they're saying, Loper-Bright is not an automatic ticket out of jail for every reg issued before Loper-Bright, right? And I do see it attempted to be used in some cases that way, in some advisors. You got to do the work, okay? Because by default, the Supreme Court ruling says we're going to presume the prior cases are right. And it's up to you to present the full evidence and carry your burden, to show why, in essence, we should reconsider this in this background. And they said, if you read the actual cases, and this was the judge's ruling from the tax court, he said the courts there did find that independent of the Chevron doctrine, that this was the best reading of the statute. So it would have met the Loper-Bright standard. So in any way, that's out. Finally, they raised an appointments clause. This is really the Hail Mary. We see this a few times in recent years. The court reaffirmed that IRS appeals officers are not Article II officers of the United States, and therefore the appointments clause of the Constitution doesn't work. We've been down that path a couple of times here. So, it's not 3 strikes, you're out. In this case, it's 4 strikes. They whiffed on all 4. So ultimately, the tax court granted the IRS's motion for partial summary judgment. It ruled the mere offer of a conference by the IRS, even if made strictly via correspondence or a phone call, constituted an opportunity to dispute under IRC Section 6330C2B. So that's the key. That is your offer to dispute. Once you have that, you have an opportunity. If you turn that down, right, we're in trouble. In essence, you can't play procedural games, at least if you're not right about being able to get, yourself to pay a small amount of the penalty and end up in the venue you want to be in. You try to do this by strategically waiving or ignoring IRS appeals office offers in hopes of preserving an underlying liability challenge for a later CDP hearing, right? This backup strategy didn't work, right? Failing to engage with appeals when an offer is clearly extended legally locks in liability, and it precludes you from disputing the merits of the tax or penalty during subsequent collection actions. So, again, as I say, pretty much we're pretty sure it was a high stakes game that was being played here because, and to be honest, they're probably right. Appeals was no way going to waive this penalty, but the court didn't care. So let's look at the underlying legal standard that governed this outcome. While collection due process preclusion issue is reviewed de novo, the statutory text of Section 6330C2B strictly mandates that a challenge to the underlying liability is only permitted if the taxpayer did not otherwise have an opportunity to dispute such tax liability. The court relied heavily upon Treasury Regulation 301.6330-1E3, which clearly defines this opportunity to include a prior offer for a conference, regardless whether the offer was made pre-assessment or post-assessment. You decline that offer, you're in trouble. The tax court emphasized that this is a purely objective standard. The IRS letters provided clear written instructions on how to protest the penalties. By choosing to ignore those instructions, the taxpayers legally surrendered their right to dispute the liability. Thus, they couldn't backdoor their liability dispute into the courtroom and into the tax court via, we're going to dispute in CDP. Now, again, it looks suspicious. It looks awful lot like, to be honest, the only rational way to read it, that the goal was to pay a part of the penalty and get a more favorable venue that the court found to be more favorable. Or I should say that their advisors felt would be a more favorable venue. They really didn't want to go in the tax court. Now, when that gambit failed, they didn't pay the full penalty. That gambit has failed, and now we have collection action started. Now suddenly they're on this Hail Mary method of trying to, bring it back to life, their challenge, even in the court that they apparently didn't want to bring the challenge in front of, because that would seem ought to have been the ultimate result had they gone through appeals. They had an attempt to challenge. Now they're going to be issued the right to go to tax court. And that's not where they want to try this. Remember, if they try it in tax court, they're not really going to have a chance to dispute it in the district court or court of federal claims. So high stakes standards. Now, for us CPAs and EAs, we're not playing that game because, we're not going to be the party representing them in the Court of Federal Claims of the U.S. District Court, right? There's only a few EAs and CPAs who can actually represent a client in the U.S. tax court. If you haven't passed the U.S. tax court exam, you don't have that right. So, bottom line, this isn't our game, but it is important to understand the game, right? About the issue of waiving your right to challenge. And also, you probably should be aware and at least raise the issue, even if counsel's involved and counsel suggesting going this route, of noting this case and that, we don't have a backup if, in fact, their partial payment standard doesn't work and they get thrown out of district court or the court of claims. We've given up that right to try a later challenge through the collection due process method to get this done. So, in essence, understand that it really do have to choose, where do we want to go? And the risk of trying to argue that you could divide the amount in such a way that you could just pay a portion of it and still end up with full jurisdiction in the district court or the court of federal claims. So this infographic is our visual summary of this case. On the left, the taxpayers attempted a failed strategy by intentionally refusing appeals to circumvent rules that bar liability challenges in collection hearings. Now, again, it's clear this was the backup strategy, right? But the first one failed. So now we're on backup. The court's answer here was very clear. You're not going to get a second chance, right? A mere offer to dispute, even if communicated strictly via formal correspondence, legally constitutes an opportunity under the statute. Actual participation in a conference is not required, right? And furthermore, the infographic highlights a key way that legal defense, had failed. The court confirmed that recent Supreme Court shifts in administrative law, particularly Loper-Bright, we see a lot of Loper-Bright discussions, do not overturn the established precedents that govern these preclusion rules unless you can show why they should. Loper-Bright opens the door to overturning, those regulations, but it doesn't just automatically do it for you. Right? We need to be able to basically carry the day and show why it is. So, like I say, skipping the appeals conference, there is a discussion, should we intentionally refuse appeals? And there obviously are strategic issues here. And ultimately, we as non-attorneys, right, the non-attorney group listening here, ultimately the top call on this one is going to be somewhat outside of your range, except to note that we're not going to lose our rights in appeals. We're going to lose because not going administratively, if we get into collections where, it gets thrown back at us again, we're not going to be able to raise the defense there. So that's going to be the problem. We're going to have an issue. So keep that in mind. Now we're going to go into a case, the OTE Project LP versus Commissioner, Tax Department Decision 2026-21, issued on February 23rd. This is a complex world of partnership taxation, which is complex in any event, Subchapter K in the Economic Substance Doctrine, right? This case involves a massive, highly engineered $714 million basis deduction claim that the IRS challenged and was ultimately disallowed by the tax court. So let's start talking about this case. Right? How do we get this massive deduction? There was an underlying restructuring, right? They operated a TEFRA partnership called OTE Project LP, or OPLP when you read the case, which acted as a master developer for real estate because OPLP had substantial long-term obligations to complete infrastructure. It deferred profits using a completed contract method of accounting, or CCM. A dispute led an arbitrator, so the partners get in the fight. An arbitrator essentially ordered the separation of the joint entities instead of a standard dissolution. Okay, so that much up to there is not really the tax driver. Right, up to that point, we just have the partners aren't getting along, and eventually it was ordered that we're just going to divide this thing up. These guys don't get along, divide the partnership. Now, instead of basically using a standard dissolution, the taxpayer engaged top-tier advisors who orchestrated a highly complex restructuring utilizing new finance companies, or FinCos as referred to. They deliberately separated intercompany promissory notes from the ongoing construction obligations to retain their completed contract method deferrals. Subsequently, in 2007, comprehensive estate planning transfers resulted in a 50% or greater change of ownership. That triggers a technical termination of, OPLP under IRC Section 708B1B. And bingo, we're going to have a technical termination at this point, right? And this is where the aggressive strategy was deployed. Because OPLP had a Section 74 election effect, the taxpayer argued the technical termination mandated a Section 743B step up in basis for the 99% limited partner, QP LLC. Relying on a strict mechanical reading of the Treasury regulations, the taxpayer ran a hypothetical liquidation calculation. You remember that's in the regs, right? Been there, and arrived at a negative $866.9 million basis for OPLLC, the limited partner. Okay, so their inside basis is negative $866.9 million. This resulted in a claimed positive basis adjustment of over $867 million to get it back up to zero, right? Now, fast forward 5 years to 2012, where OPLP formally liquidated. At that time, the partnership finally had to recognize about $760 million in deferred completed contract method income. Completely wipe out this massive income recognition, they claimed the basis deduction of $713.7 million, directly linked to that engineered Section 2007, create a bunch of 743, blob of basis that we're now going to use as a deduction. Okay, by a very mechanical reading of the reg. Now, the IRS issued a notice disallowing the deduction, and the tax court agreed with the commissioner. The court focused on the statutory text of 743B, which mandates that a partner's, proportionate share of adjusted basis must be determined by their interest in partnership capital. And the court said this is the fatal flaw in this attempted mechanical strategy. OP-LLC actually possessed a massive negative capital balance, $912 million, due to prior tax-deferred obligations of those FinCo entities. In a hypothetical liquidation computation, the taxpayer completely ignored this $912 million capital, 704B capital balance. The court formally stated that ignoring this negative capital flies in the face of reality and proper tax accounting. Your claiming allocations have substantial economic effect. Here's the catch. If you're going to claim there's substantial economic effect to this allocation, a partner with a deficit capital must have an unconditional obligation to restore it. We know there's the alternative method, but that didn't apply here. They create a huge negative capital account. The court ruled any correct 743B adjustment absolutely must account for this deficit and the obligation to restore it, rendering the calculation incomplete and invalid. Yes, tax basis was negative, their share of the capital, but they also meant that their tax basis capital account would have been negative, and that suddenly renders the whole issue, you got to offset the two. The court said in that case, you have got to offset to take into account that fact you do not have a capital restoration obligation, and thus that loss is not allowable. We're not going to do it. That's the way the court looked at it, okay? Now, the court rejected the idea that mechanical compliance 743B shields a transaction from judicial review. They said, no, mechanical compliance, those regs, does not make this all okay, right? They applied the Ninth Circuit's holistic framework in this case, did have practical economic effects after the tax loss creation. While resolving the brothers' disputes had a business purpose, the use of the FinCo restructuring had nothing, was not necessary. They went out of their way to design something to try to engineer a tax benefit. So that was an artifice to facilitate an indefinite tax deferral and a tax-driven sham. Therefore, economic realities prove the families indirectly retained all their payments and construction obligations. And so, because this loss was generated by something without economic substance, the court said that's a second reason to totally disallow this adjustment, right? That's how we do this, okay? Now, the good news was they did have a penalty defense. That's kind of helpful to them, right? The IRS assessed a 40% gross valuation misstatement penalty and a 20% negligent penalty. Now, the taxpayer asserted reasonable cause under 6664C1. Now, remember, in this case, the valuation penalty, right, we're going to get there, is not on a contribution. So, a charitable contribution, we're looking a little different. Okay. Taxpayer relied on multiple independent competent advisors, Ernst & Young, Loeb, and McKee Nelson, all of whom basically told them this was fine and it worked. They provided, basically the advisors were provided full and accurate business details, unburdened by conflicts of interest. Right. This is not a case of a third-party promoter came to them and sold them this structure. This is they hired people and had them design it. And these people were going to get paid whether or not they executed this transaction. That makes all of this hugely different from places where we don't see this allowed for reasonable cause. And the court said, due to this extreme complexity of subchapter K rules, the court said, okay, they are not going to get the penalties. They're going to still have a problem, but they don't face these extreme penalties. Okay. So let's talk about this, unpacking the basically tax court memorandum 2622, the OTE project. What actually went on here in this particular case? Well, the tax strategy was, of course, to attempt to create a deduction. We have a legitimate reason to split this partnership. No tax reason there, which is good news generally. But then we decided to study ways to get a tax advantage out of it. And we engineered a special structure in a termination to trigger the termination and have these things go on that would generate this $743 million deduction on termination, right? And so even though there was $920 million of deferred profits, in essence, we were able to offset those, right? Unfortunately, the court, as we noted, said, no, we're rejecting that. You can't ignore the negative 704B capital account that you created. That's something you got to, pay attention to. You didn't, right? That's a problem. The total deductions to be allowed were zero. Totally rejected that. So they basically, essentially threw out the deductions of nearly $714 million. They did, however, allow them to get out of the accuracy-related penalties. Okay. Now, again, so bottom line, they disallowed it. There was no economic substance to this. It was just creative to engineer a tax benefit. It was not necessary for the business reason. The business purpose could be satisfied by many by other simpler ways of doing this. You engineered a tax outcome that really had nothing to do with anything. So, in any event, but they had reasonable cause because in this case, and this is what distinguishes it from all those tax shelter cases, in essence, they had reasonable cause because they didn't just rely on the promoter, right, doing things like that. And they actually got advice from parties that were going to get paid whether or not they implemented the strategy. So that's kind of the big thing. Next up, Section 6038B penalties. This is the Safdie versus Commissioner case, right? And this came out on February 27th, 2026. So let's look at this dispute here. This is a case from the Second Circuit Court of Appeals. And it is case number 25501CV. So how did the thing get started? The IRS assessed Joseph Safdie. I'm sure his name's not pronounced that way, but we don't unfortunately get pronunciation guides with the judges don't provide that with our cases. So I apologize to Joseph, but they assessed him $50,000 in penalties under 6038 for failing to report control of foreign business between 2005 and 2009. This is triggered by a number of four different foreign filings, but the one you're probably going to hit most often for individuals would be the Form 5471. Right? He failed to report his control of the entity. Now, he refused to pay, which prompted the IRS to file a federal tax lien. Now, the taxpayer challenged this collection activity to collection due process hearing, and he petitioned the tax court, right? In essence, the tax court under Judge Holmes sided with the taxpayer, and they ruled that Congress never explicitly authorized the IRS to use the administrative assessment process in Section 6038B. According to the tax court, the IRS wanted to collect these penalties. They couldn't just assess them and issue liens. They had to go through the lengthy process of filing a lawsuit in federal district court. For this reason, the IRS appealed this decision to the Second Circuit. Now, at the Second Circuit, the central issue was highly straightforward, but highly consequential. Does the IRS have the authority to collect 6038B penalties, not filing in 5471s, through administrative adjustment, or must they obtain a judgment in federal district court? The U.S. Tax Court is taking the position that they've got to go to district court, right? Now, that assessment is the critical engine that sets the IRS collection powers in motion. An assessment allows the IRS to seize assets, freeze bank accounts, and issue liens without ever stepping foot inside a courtroom, right? While IRC Section 6201 already broadly authorized the commissioner to assess all taxes and assessable penalties, the actual text of Section 6032B is silent on whether this particular penalty is an assessable penalty. Because of this ambiguity, the Second Circuit had to look beyond the text to the history, purpose, and structure of the law in their view. And as the Second Circuit did not agree because it didn't have the magic words that this was an assessable penalty, that we weren't to conclude it wasn't. Now, the Second Circuit looked at the legislative history. Why did this section get to where it is today? And Congress enacted this section, 6032B, in 1982 because the existing penalty, which reduced a violator's foreign tax credit under subsection C, right, was deemed too complicated and practically useless against taxpayers who paid no foreign taxes. The entire purpose of adding B was to give the IRS a simple, straightforward penalty to impose. The court reasoned it was highly implausible that Congress intended to create a streamlined penalty, but simultaneously require a lengthy, complicated detour through the federal district court to collect it. The court quoted that Congress wouldn't put even more logs in the way of the tax harvester, in their view, right? The court leaned heavily on the doctrine of legislative acquiescence as well. The IRS has been administratively assessing this penalty since 1982, and Congress has amended this section 7 times over 43 years without ever saying, IRS, you have to be going to district court. You can't just assess this penalty. Congress was aware the IRS was assessing it for 43, it was basically 43 years, and they have never enacted a provision that made it clear that they shouldn't be doing that this should go to court. Okay? Because basically the idea was the C penalty is still there to offset the foreign tax credits, but the foreign tax credits, the ability to throw out foreign tax credits is reduced by the amount of the B penalty that's been applied. That was the idea. So it gave the IRS an ability to go to court and get the B penalty out of there, right, without having to go through the whole mess of the C penalties, which are very messy, complex to compute. They still can do it if they want to, but B is the quick and easy way of getting the penalty. Now, the court looked at the statutory structure, which specifically the coordination clause in 6038C3 that I've been talking about here. The clause required the foreign tax credit penalty be reduced by the exact amount of the Section 38B penalty imposed. Now, the panel deduced that Congress clearly intended for the IRS to impose both penalties simultaneously. If the IRS had to wait for a district court judgment to finalize the B penalty, it would completely disrupt the coordination, as the court put it, throw sand in the gears of the enforcement scheme. The court also warned about the practical nightmares of bifurcating these proceedings between the tax court and federal district court. It would cause a duplication of effort because both courts would have to hear the case, right? The taxpayer hasn't paid, right, the penalties, right? And they haven't paid, they haven't paid back the federal tax, the foreign tax credits. So the district court would first have to try the case under the 6038B issue. Only after they tried that would we then go to tax court. We would rehear essentially the same damning case twice. It would invite taxpayer gamemanship where taxpayers might race to get a favorable factual determination in one court and then claim that binds the others because they're the same facts. Yeah, so like they said, this is an insane method, is what they're saying. Congress could not have meant this. Okay. Now, the taxpayer made a final attempt to argue the Title 28, specifically Title 28, United States Code Section 2461A, was Commissioner's exclusive collection authority. But the court rejected this, noting it was an administrative judiciary statute that wasn't historically used for tax penalties like this. Ultimately, the Second Circuit firmly aligned itself with the D.C. Circuit, citing the recent Farhi versus Commissioner decision, which is the only other appellate court to have decided this exact issue. Now, this is important to understand right now. The tax court, even though they've been overturned on this, right, in 2 cases now, even though they have been overturned, including this case, which basically started the whole mess, it's still a published decision for the tax court. And so outside of the D.C. Circuit, which means you got to be in Washington, D.C., or the Second Circuit, which is, in the Northeast, every other circuit right now, the tax court is going to rule against you or rule against the IRS. And, it kind of raises the question, well, is IRS just going to keep taking this to courts of appeal every time? And of course, if they do, are they going to keep winning? At what point would the tax court reverse? Generally, they start questioning whether they should reverse around the Third or Fourth Circuit that overturns them. Then they start considering reversing their decision. But if they don't have that yet, they're holding out for a split, in which case then you go to the U.S. Supreme Court. Now, obviously, in either the D.C. case or this case, I believe the D.C. case is probably past the time frame to ask the Supreme Court to step in. But this case, they could clearly ask for an en banc rehearing by the Second Circuit as a whole, or they could ask for the U.S. Supreme Court to step in. I doubt the Supreme Court would step in, especially because this is now two circuits ruling the same way. And the Supreme Court kind of likes this theory of unless they really, really are interested in something, which rarely is true about tax penalties, believe me, they're more likely to just let the process play out when it appears that the circuits are coming to all the same decision, and that can eliminate them needing to get involved. So unlikely. So in essence, this final ruling is a decisive victory for the IRS. Based on its history, purpose, and structure, this penalty is assessable penalty. And by the way, it is right now. If your client's in the Second Circuit, you're in New York, right? Your client's in New York, this is an assessable penalty, right? The Second Circuit is going to bind them even if you go to even win the tax court, right? They're going to basically follow the ruling of the court in the Second Circuit. So Second Circuit, your only option in the Second Circuit would be to pay it and then sue in the Court of Federal Claims. But at that point, we're in a mess as to what it is. They didn't have a right to assess it. You're going to kind of pay it and then sue for a refund of claiming it was assessed illegally, which then will probably just cause us to hold a hearing on the basic, would have replied anyway. Yeah, I don't know we're going to get far there. But that would be the issue. You would have to go to the Court of Claims. Those would be your only option, assuming you find a way in, assuming you actually like to go there, which is the issue. So this infographic is a summary of this decision's impact on international information reporting enforcement, at least in the D.C. and the First Circuit. The financial exposure is rather nasty. This is a $10,000 penalty per year per entity. In this case, the taxpayer had failed to file it for 5 years. That's how we get to $50,000. Now, the right side of this illustrates why the court ruled for the IRS, right? 43 years consistent agency practice with Congress not objecting, the clear legislative intent in the view of the Second Circuit to simplify enforcement, and the need for procedural coordination with the foreign tax credit reductions. All of those claims that, you couldn't read it. Now, what the tax court was doing is claiming is doing a strict textualist reading. Again, saying, that they have the right to assess assessable penalties. But this penalty never says it is assessable. So the question becomes, how do we determine that? And, the court was kind of looking for an explicit label. And the Second Circuit and the D.C. Circuit says no, because, the ultimate result is crazy. And Congress knows that they've been doing it this way for 43 years and has never raised an objection. Basically, the taxpayers need to find a circuit where they're going to disagree with that ruling. But the problem is the taxpayer is going to keep winning at tax court. So all the IRS has to do is not appeal it, and that circuit will never be heard on this issue. And the IRS may be able to accumulate, 4, 5, 6 circuits with favorable decisions and effectively pressure the tax court to swap. We're just going to have to see how it goes, right? So bottom line, in the First Circuit and D.C. Circuit, don't look at trying to rely upon the claim that these are not assessable penalties, right? To, in essence, say the IRS had no right to go forward with their collection, because you're going to lose, unless you figure out a way to get to Court of Federal Claims. That's going to be because you're going to lose in the local district court, you're going to lose in tax court, because they're both going to feel bound by the binding district court decision. In the other circuits, It'll work through tax court, and then your gamble is, will the IRS want to risk going to your circuit? My gut tells me that therefore it might be safer to go this route of claiming they had no authority in the Fifth Circuit than it might be in some others. Just saying. Although, remember, the Fifth Circuit was nastier on foreign penalties than the Ninth when we talked about FBAR filings. So I don't know if these foreign penalties are viewed differently in the Fifth, which maybe then it's safer to go to the Ninth. We're not sure. But in any event, we got to focus our efforts on reasonable cause defenses in the First and DC circuits. That's the most likely route to doing this, because otherwise, remember, even if we can get into the federal circuit, nobody knows how they're going to rule or how the federal circuit would rule. So it's not like it's a given you're going to win by going that route, if you can. Well, this took a look at some of the things developed this week. We looked at delayed applicability of Secure 2.0 RMD regulations, preclusion traps in collection due process hearings, partnership basis adjustments got heavily scrutinized, and IRS assessment power for foreign reporting penalties, right? Thank you for listening and being here this week. Glad you all came by. My email address for quick questions is edzollars@currentprotectionalmost.com. You'll see that on the screen if you're watching the slide version of this. I also monitor Connect groups for the following state societies: Arizona, New Jersey, Idaho, Minnesota, Illinois, and Washington. So if you are a member of the state society CPAs in those states, you post there and I see your question, I may be able to answer back and tell you what I think the answer is. Otherwise, though, if not, we're in March now. We are coming up on the first absolute, or not absolute, but the first deadline to make sure you get all your extensions in on March 15th. This one is generally considered less pressure because it's pass-through entities. Certainly in partnerships, as we've discussed in the past, you probably want to extend any partnership that can't opt out of the BBA centralized audit regime, simply to have a right to extend your time to file a superseding return all the way to September 15th, because that way, in case you find a change or something comes up that says, "Oop, there's a problem in that return," we can fix it without going through the whole BBA mess, of having to go with the administrative adjustment request. So that's there. But also, to be honest, it probably doesn't hurt for S corporations because there are other reasons one might like a superseding return, including making any election that had to be made with the original return, as long as that was by the date the return is filed, including extensions. Make sure, again, any election had to be filed by the return date for the return, not including extensions. You don't get that. Even with the superseding return is not going to change that. Everybody has until the original due date to supersede, and any superseding coming on extension it would be too late to make that election, so you can't remove it. There aren't a whole lot of those, but there are some. So just be aware that's there. Otherwise, we'll see how things go. Again, it's always fun in tax season because you get lots of work going on. So I may miss one or more weeks during tax season to warn you ahead of time. But otherwise, thanks for being here. And we look forward to seeing you next week on current federal tax developments.